My name's Aaron Stevens. I'm a partner at King and Spalding here in London, and I have the pleasure and the privilege of introducing Lisa Osofsky and Rich Donoghue this morning and facilitating a discussion between them. Just very brief introductions to a couple of people who probably don't need an introduction, but I'll do it anyway. So Rich is the U.S. Attorney for the Eastern District of New York, where he oversees both the criminal and civil divisions of that very important U.S. Attorney's Office. He actually started off his career as a paratrooper in the 82nd Airborne Division, and then subsequently was a member of what's known as the JAG Corps. If you don't know what the JAG Corps is, just go back and watch Tom Cruise and A Few Good Men, and that'll give you
just like
picture. He then was appointed as Assistant U.S. Attorney in the Eastern District before and served for a number of years there, and then actually went in-house at a global technology company where he was Chief Litigation Counsel before being appointed back as the U.S. Attorney in the Eastern District. I think I'm right in saying that you're the first sitting U.S. Attorney that we've had at the Institute. We've had a number of people from Main Justice, but never a U.S. Attorney from an important office. So that's great, and hopefully you can spend some time educating people about what the U.S. Attorney's offices do vis-a-vis Main Justice. Lisa Osofsky, who we all know well here in London, Director of the Serious Fraud Office since September of 2018, I think, when you were appointed. Has served in other functions as well, both in the U.S. and here in the UK. She started off her career as a federal prosecutor in Chicago. She served as a deputy general counsel of the FBI in D.C., moved to London in late 90s, early 2000s.
About 20 years ago.
Yeah, about 20 years ago. And actually did something very unusual for a U.S. lawyer coming to London. She qualified as a barrister. And then had a succession of really interesting roles, including being the first money laundering reporting officer at Goldman Sachs International, working as the European chair of Exeger when they were the monitor of HSBC during their deferred prosecution agreement. And then, as I said, appointed the director of the SFO last year. So we're extremely privileged and happy to have them both here. And after that short introduction, I thought I'd kick proceedings off with a quick question for Rich, and just kind of set the scene for this comparison of U.S. and UK law enforcement. And it's something that comes up a lot in just discussing the DOJ with people here in London who practice in this space. And a lot of non-U.S. lawyers in particular think of the DOJ as some sort of monolithic bureaucracy sitting in Washington, D.C., and everything happening there, when in fact, it's much more of a countrywide organization with U.S. attorneys' offices around the country. And I thought it'd be helpful if you could just describe how the U.S. attorneys' offices interact with Main Justice and other law enforcement agencies around the country, and including in how the FBI and DOJ interact and how the FBI can support DOJ prosecutions.
Sure. Well, thank you, Aaron. Good morning, all. I'm very glad to be here. I'm particularly glad to be here with my friend and colleague, Lisa Osofsky from SFO. Our organizations work very well together, and I think that's due in large part to Lisa's leadership. In terms of the question, certainly DOJ is not a monolith. It may, from the outside, appear to be at times, but it is important to keep in mind, particularly as you're advising a client and dealing with a situation, who the players are and what their background and perspectives may be. So there are 94 U.S. attorneys' offices within the U.S. Justice Department. We out in the field, as they say, like to remind our colleagues at Main Justice at the department in Washington that we've been around since 1789, since the first Judiciary Act, which created the U.S. attorneys' offices. The department itself, however, did not come into being until after the U.S. Civil War in the 1860s. So we've got about 80, 90 years on them. The division of labor is not always entirely clear, although you need to keep in mind that within these U.S. attorneys' offices, particularly some of the larger urban offices like mine, like the one Lisa served in Chicago, you tend to have these large, sophisticated white-collar practices. So I have a little more than 100 criminal prosecutors on my staff, plus about 50 civil prosecutors. Of my 100 criminal, we have about 15 that are dedicated exclusively to large-scale, sophisticated, mostly international white-collar practice. As a result, they're able to develop some significant experience. They deal with not only FBI and other U.S. players such as regulators, SEC, CFTC, but they deal on a daily basis with our international partners. And as a result, once you've worked through these cases a few times and grown up in this practice area, they become very skilled at dealing with large corporations, international players and regulators. And then they interface, obviously, with our main justice components, such as the DOJ fraud section. DOJ fraud section and MLARS, the money laundering and asset recovery section, are the two main players at main justice that we deal with in this field. They are great professional experts in this practice area. The DOJ fraud section actually has administrative oversight over the FCPA practice, which of course is very important to us and others. So you cannot conduct FCPA investigations without their involvement. But there is this interplay between main justice and the particular U.S. Attorney's Office that you may be dealing with. And if you're advising a client, I would suggest that you look at the office that's involved and look at, say, the FCPA cases that they have dealt with over the last couple of years to get an idea what their approach may be. In terms of the FBI and other investigators, they have their own views, certainly. Again, very sophisticated in this field. They've done a lot of this. They've got reach around the world. Their input is incredibly important. At the end of the day, prosecutors must make prosecutorial decisions. But neither the FBI nor any other investigators that we deal with are shy about making their views known, and that's good. And we certainly take all that into consideration. We work very closely with our investigating agencies to make sure that we understand the situation and that we're taking the right approach.
The only thing I'd add that might be helpful, which I know Rich wasn't asked, but I realized I first came here working on a big bank failure where the big push was coming from a local district attorney, Bob Morgenthau, in the Manhattan DA's office. So the only other thing I'd throw in there is, it's not a DOJ question, but it is, you'd want to look at the terrain and see, do I have a very assertive, sophisticated local prosecutor? Cy Vance has taken his place. He's now quite famous because of various cases he's got on, and you can tell from the media that gets generated, these are active offices. I think that's worth at least thinking through when you're marching ahead and advising your clients.
And Lisa, do you want to pick up a little bit about the SFO and how it's different and how it's unique and specialist purpose and mission here in the UK and how that differs maybe from the US setup?
Sure. I think we are, I grew up as a prosecutor like Rich, where, well, you grew up before because you were doing Jancourt cases, which probably taught you an incredible amount about how to try a case. But I grew up using the different agencies, whether it's FBI, Postals, DEA, whoever did the investigation, but we do it together. We would work, and especially when you're a junior prosecutor, you're pretty much learning your case from your agents and how to work them from agents. But in this country, in the UK, we don't necessarily have that kind of structure throughout our country. Instead, what we have is within the SFO, which is our organization, we've got the prosecutors, the investigators, the digital analytic folks, the accountants. We're all housed under one roof. And that was in response to a concern about 30 years ago that we weren't really dealing with fraud cases all that well in this country. As we can tell now, 30 years later, everything's perfect. We're dealing with all our fraud cases wonderfully. I'm sure anyone who's practicing in this jurisdiction could nod to that one. But what it's done is it means that we actually work our cases from start to finish. I've got a certain amount of, in fact, quite a lot of discretion in terms of what we take on. It's really one of the important factors we're thinking about when we take on an investigation is this a case that needs these specialist skills where we really need everybody together from start to finish to investigate this thing properly, to get it to charge or not, depending on what the evidence uncovers, and then to get it through resolution. Because the common model in this country is a little more, the police will investigate and hand it to the prosecutor. And, really not working through from the start of the investigation. We're not the only people who work with investigators. There's something now new in this jurisdiction called the National Economic Crime Center that's meant to bring a lot of us together, people like the SFO, the NCA, the National Crime Agency, the HMRC, the tax folks. It's meant to have a lot of different investigatory agencies and regulators all working together. It's a fairly new, it was born less than a year ago. And some of the idea is to making sure we're all sharing information appropriately. So I think that's broad brush some of the differences.
Yeah, no, that's very, very helpful. And I think something that people here are always interested in hearing about is just how are the DOJ and the SFO and other authorities on both sides of the Atlantic working together and cooperating? Is that something that's evolving still? What's the kind of latest trends there?
Well, as you can tell, we hate each other. We wouldn't even sit next to each other at dinner or anything like that. I don't know. I could let you. Our experience is very positive.
Yeah, it's definitely very positive, and certainly our work with the SFO, I think, is exemplary in this field. It's always changing. It's always growing. Your prosecutors are changing and growing. But our interaction with national and international partners is expanding constantly, right? So in the Eastern District, for instance, just in the last year to 2 years that I've been back in the office, we've worked with, obviously, the UK, the Swiss, Singapore, Brazil, and on and on. It seems that every large-scale white-collar case we work, I say, is a mini version of the UN gone bad. It seems we need at least 6 different countries involved in every fraud. The bankers have to be in one region, and the architect has to be on another continent, and the bank somehow is in, or someone flies through JFK in New York or whatever it is. But I'm always amazed at the sprawling nature of all these large-scale white-collar criminal enterprises and matters. So we are necessarily working with our foreign partners, and actually it's been very good. Once you work through it with the authorities in Brazil or Singapore or the UK, once you kind of have it down, you understand their perspective a little bit and you understand their process better, and it makes it a lot easier to do it the next time, which is why this, to some extent, becomes a basis for future work. But I think our work is excellent together. We do have limitations, obviously, maybe grand jury materials or things like that you can't necessarily always share with a partner. But we find ways to work through it and make sure that everyone has the information they need, because at the end of the day, we all recognize that a resolution is going to have to be a joint resolution. And so you're working toward a common goal.
I couldn't agree more on that. I think the only thing I'd add is that it can be easy, if you don't know someone, to think that what they're doing is designed in some way to thwart what you're doing. And the positive way to think of that is, once you start talking to each other and understand each other's processes, then I get that, Rich has grand jury material that's got to be treated a certain way. It's not that he's being difficult, it doesn't want to share it. It's just that, he goes to jail if he does. He gets held in contempt or small little, events to that effect. Or, in our case, we've got really slightly different rules. Let's say the Fifth Amendment, in the U.S. is the Fifth Amendment. You're never allowed to comment on right to silence. In our country, an adverse inference can be drawn if someone maintains their right to silence in a certain situation. So some of it is just a matter of talking to people so you understand where's the absolute no-go lines. And if we know can't do it this way, as Rich says, we look for other ways to get around. Not to illegally get around things, but to figure out gateways where we can share information and share common goals. And we get that you're representing clients out there who want global resolutions. You don't want to, make sure everything's great with the SFO and find out, the U.S. is still out there looking for its justice. So we get that, and we know that is also, if we're ever going to find anyone and really find where the assets are and where the bankers are, we actually have to make sure we're working well with our partners. So that's been hugely important. I just got back from a conference with 100 countries represented, the International Association of Prosecutors, and I I was looking around thinking like, oh, this is a great group. We had the head of every country basically for prosecution. I was thinking, what fun, what a good group. I was thinking, actually, I may be one of the few people in the world who would think this is a really fun group to be hanging out with, but I liked it. And what it shows is we all get it, that we need to work together, and the better, criminals do it. Criminals love nothing better than to escape jurisdictions, hide money all over the place, make sure we can't get at it. So my feeling is if the criminals are going to operate this way, we've got to be on our best in terms of operating sensibly there too.
And just picking up on that thread of international cross-border cases, the last 5-6 years has really seen EDNY emerge as a force in terms of FCPA prosecutions in particular, but other types of white-collar cases outside of the U.S. or involving non-U.S. companies. I don't know if you can comment on that trend and on what EDNY is doing in terms of enforcement of law, around dealing with non-U.S. companies.
Sure. I was lucky enough to come back almost 2 years ago to lead the office, and I was remarkably impressed at the progress they'd made over the last couple of years in terms of large-scale international white-collar practice. I think some of it is just obviously the people who were there, and success builds on success. The office has used the last couple of years to build up a real muscle memory about how to do these cases and the relationships that are necessary to do these cases. I think that it's certainly been a priority for the department. You've seen that across administrations now, that FCPA enforcement is a priority for the department. It will remain a priority for the department. I think regardless of what happens in elections in this upcoming year, I just don't see a change of administration changing all of that, because it is a reflection of the business environment that we're all operating in. So we've had an opportunity to do a lot of great cases. We have a lot of cases underway. We have a trial starting tomorrow. And so we have no shortage of work ahead. Certainly 1MDB is out there. The Bustani trial starts tomorrow. We've had a lot of resolutions, many of which resolved in criminal convictions, sometimes for parents, sometimes for subs. We are certainly focused on holding individuals accountable, because I think that's the only way to really change a culture within a company or within a practice or a business environment. And so we've had the opportunity, the luck, and the fortitude, I suppose, dedicated to this practice area, and it will continue as long as I'm there, certainly, and I'm sure well beyond.
And you mentioned individual accountability. Is that something that either of you want to expand on in terms of, the role of individual accountability in creating that deterrence, and what you're doing to try to make sure that's happening?
Sure. I agree with Rich. Obviously, we want to hold, prosecutors want fair convictions. I think it's fair to say that if we think there are culpable individuals, we think they ought to be held accountable, obviously, within the bounds of justice. And we've got a different culture in this country. We don't have a history of plea bargaining. We don't even have DPAs for individuals here. We've got a very different culture when it comes to individuals. And so one of the questions is, how difficult can it be to get individuals convicted in the UK? And we have a different test, really, when we are thinking about resolving a case with a corporate through a deferred prosecution agreement. We need a certain quantum of evidence to continue to discuss resolving. We have a different standard when it comes to individuals. Also, our sentences are quite low. So some of the common wisdom is, what do you got to lose? Roll the dice, rack them up. Let's see how I can do in front of a jury. So I think there are different ways that our jurisdictions will end up moving against individuals. I think the bottom line is the same. If they're culpable individuals, we need to be investigating them. We need to be figuring out whether we can call them to account. The ultimate result will not end up with the kind of stats I used to have as an AUSA in Chicago, where many, many, many of our individuals pled guilty. And that was just part of how we did business. That is less so in this jurisdiction. which means we're fighting more of the cases in court, which I welcome that opportunity. I think we've got a system that's the envy of the world, whether you're talking about the UK and the US in a lot of ways. And we welcome the challenge and the rightful challenge. We want people who are properly convicted. And so, yes, we have the same goals. I think you might see slightly different results. And I've tried to give a few of the reasons why.
And just switching gears a little bit to corporates, then, the SFO has recently issued its corporate cooperation guidance here in the UK. I don't know if you want to just speak briefly to what you think are the key takeaways from that guidance that advisors should be bearing in mind.
Sure. I think most experienced practitioners who've done a number of internal investigations or run a number of cases wouldn't have been shocked by what they saw. The goal was a little transparency. What are we thinking? What kinds of things are we thinking about? But you'll probably notice it doesn't really look all that different from some of the guidance you'll be seeing out of DOJ or out of France, the AFA or the PNF or whoever's guidance you're looking at. There's been a bit of a convergence in some ways out there, which is good. I mean, it means we're not asking people to do a whole range of different things. But in a nutshell, you'll take away that you just complying with the law doesn't count for. It's not enough to get extra cooperation credit. You're going above and beyond. And I think that's the kind of understanding practitioners had before they read our guidance, and I'm sure still maintain.
I mean, one of the differences that people have picked up on is the SFO guidance that asks or requires companies to consult with it before interviewing employees, taking personnel or HR actions, or taking other overt steps in an investigation. And at least in broad brush terms, the DOJ is perceived as being a little bit happier for companies to do some preliminary investigations themselves before getting in touch with DOJ. Is that a fair comparison, do you think, or is it actually a bit more nuanced than that in terms of what the DOJ's expectations are and as compared to the SFO?
Well, I'm sorry, I know Rich wants to talk. Because I think mine will be really easy, and then we'll get into the guts of what. I mean, if you read that whole sentence, what we say is to avoid prejudice to the investigation, comply in a timely way. So really, the message is. Let's give an example. Let's say you get in, you talk to some folks, and our main defendants end up fleeing to a jurisdiction that will never get them back again. That's not cooperation. And that's the kind of prejudice to an investigation where we look at it and we'd say, that is not something that's going to get you cooperation credit. So really, it's a matter of you as practitioners advising your clients, weighing, is what I'm about to do going to prejudice the investigation and make it harder for these people to get to the truth here. So I think it may look really different. I don't think in practice, it feels all that different to me. But I'm sorry, I know I talked over you.
I think that's absolutely right. I think with Lisa's explanation, it makes it clear that we are very much of the same mind and the same approach on these things. Certainly, we expect that if a corporate client realizes they have a problem, they go typically to outside counsel and conduct an investigation. That's perfectly fine. We want them to investigate. We want them to find out what happened and to give us at least a start, and so that we can assess whether this is something we should even be involved in the first place. It may not be. So we certainly have no blanket concerns about conducting investigations before talking to us. But if you conduct the investigation in such a way that's going to prejudice something that we would do following that, obviously that's not going to be to the client's best interest.
And Rich, if you could want to just pick up in a slightly similar topic, the evaluation of corporate compliance programs guidance that DOJ updated recently, and,
right.
and how that's working in practice, and how you think that might evolve over in the future.
I think it's working well. I look at it from the perspective of someone who was in-house in a publicly traded company for 6 years, right? And how practical is this? And I think the guidance that's been recently given fine-tunes prior guidance, but it's also just a little bit more practical for both the in-house practitioner an outside counsel who's trying to help the company work through a particular situation. So it looks at the compliance programs basically in three ways. It looks at whether or not the compliance program was architected the right way, whether it was designed the right way at the outset. So you have to look at things like, the geographic environments they're working in. Are they working in high-risk countries? You have to look at the field that they're working in. Next, you need to look at whether or not it was implemented in the right way. That is, was there a real rollout within the company? Did you create the compliance infrastructure within the company? Do you really have a compliance officer and a compliance department? Do you have reporting mechanisms, et cetera? Is there really buy-in and advocacy from middle and upper level management saying that this is real, this is serious, this is part of the culture of our company? And then the third prong is whether or not you're looking at how it actually operates and making adjustments appropriately based on the actual operation of the compliance program. So do you have a third party that is responsible for receiving reports? And then how are those reports communicated to the company, and what does the company do to actually follow up and investigate? And it might be on very small matters, right? The smaller matters help us in some ways look at whether this is really functioning within the company. So there are things well below DOJ's interests, and perhaps an individual salesman maybe making some sort of inappropriate deals and based on personal relationships or something like that. That may not be anything that's ever going to rise to our level, but we look at whether you as a company are actually using your compliance mechanism to discipline people, in some cases to fire people, to make sure that you are making clear that this is part of the culture of the company. So I think it's very useful. I think it's practical and helps companies know what to expect should they end up in a situation where they have to talk to DOJ and say that we do have a real compliance program that does function, it's well designed, and it is backed up by the full weight of the leadership of the company.
And I think, as I talk to different people out there who are who are at firms responsible for their compliance function. And, we get that these are evolving programs. You may come to a place, you've inherited X, you're going to make your stamp on it. You're going to improve it. You're going to see things that you want to make better out there. And I think, we've both been in the private sector where we've seen that these are not sort of one stop, now you're done, you built the thing, in terms of embedding and making sure it's catching on the right way. You may find some flaws along the way, and I don't think too many prosecutors who have experience out there want to play the I've got you game. The point is to actually figure out how to make the programs work well. And that means you're going to have to be looking and sometimes looking for problems, and I think we get that. So you may come to us at a certain stage in the process. I know in this jurisdiction, I've got to convince a judge. We used to have Brian Levison who did all of our DPAs. I've got to convince a judge that the company has a good program or sort of good enough to be worthy of a DPA, but there's also some understanding that things may need to improve and we may need to monitor or look at that company over time. And I think both our jurisdictions and our own, I'm hearing, our own practices and our own experience tell us that that may well be a work in progress in certain situations.
Great. Well, we got started a little bit late, but I think we still have 5 or 10 minutes left. And I wanted to open up the floor to questions from the audience. And I think there should be a roving microphone, but if not, then just please shout out. It looks like there's a couple hands up there. There is a roving microphone, but no one to deliver it.
The microphone is not roving at the moment.
I don't think you need one.
I don't need one.
I hear you loud and clear.
So, as a former U.S. prosecutor who's now working in the UK, I've actually seen that despite all the conversation about cooperation and more, particularly in the way criminal cases are investigated and prosecuted. They range from whether you can use a wire and how you pre-bargain the case, or whether you can pre-bargain the case, the leverage you have over defendants, prepping witnesses. There are range of issues which, when used in the U.S., is normal. If used here, can be quite problematic. So from a
mean higher pressure or more open opportunities for people to divulge their what's really making them keeping them up at night?
I thought they were very effective techniques on the other side, but I can correct.
Well, we do have tools. I don't think they're used all that often in the white collar area, but we do have the Serious and Organized Crime Policing Act that allows us to either grant full immunity or partial immunity to witnesses who want to work with the government. Even if I don't have all the powers to wire someone up, as you say, we do work with partners who actually may have those abilities to do something similar. We don't call it that. We don't do that the way we did in the US, but there are opportunities to work with human sources, and we can work with either our NCA partners or policing partners or others if we've got an investigation that seems to merit that sort of approach. And, I think there are differences, but I think we do have the tools there. It's whether we as a country have an appetite for presenting some of what comes of those tactics to a jury. And you hear people say, juries don't like a supergrass. That's kind of the common thing I hear every time I talk to anyone who's familiar with this jurisdiction. And that is typically when an undercover situation's been used with in an organized crime case. Well, first I'd point out, bottom line, when we have white collar cases, there's a lot of paper and corroboration. So you're not just counting on somebody who's been inside. You will often have a lot of material documents showing money moved from point A to point B, this bank account, that wire transfer. And I can't talk about ongoing cases, but there are cases that we've all seen discussed in the press over the past few years where that kind of examination yields fruit. So I think we've got some tools. I think the question often gets asked whether the UK wants that sort of an approach. And I think the answer is I'm going to try to fairly use whatever tools Parliament's given me to make sure that the streets are safe for people in London and the UK. So I appreciate that maybe we haven't always done things a certain way. That to me is never a good answer. Okay, we'll never do that because it hasn't been done before. The best answer is let's explore what powers we have within the law and think about how best to make sure criminals aren't out there plying their trade.
Do you want to pick that one up at all, Rich, or should we see if there's any more?
Sure. I would just say one point that perhaps touches on that is that from our perspective, the worst development for a company is obstructive conduct, right? Obstruction is catastrophic. And so I know you're saying that some of the issues that in the U.S. might not be perceived as obstructive conduct and completely normal in terms of internal investigations and witness prep and things like that may be perceived otherwise in other jurisdictions. So I can't really comment on that, having not represented clients in dueling jurisdictions. But from the U.S. perspective, perhaps that is further down the spectrum in terms of representation and conduct. But if you get to the point where a U.S. team, it's never an individual, it's always a team, looks at the company's conduct and concludes that the company was actually obstructing the investigation, whether the internal investigation or an official investigation, that makes a huge difference in the outcome of the case. So in terms of handling your clients and educating your clients and controlling the situation, it's in their best interest that outside counsel particularly make it very clear to them at the outset that any obstructive conduct will have a dramatic impact on the outcome.
I think I saw John.
Yeah, I'd just like to ask both organisations whether you feel there's a way of increasing the pace of investigations and prosecutions in each jurisdiction, and if so, what do you think the best ideas are?
Well,
for some of the bigger corporates, investigations in this country, we're looking now at 3-5 years, sometimes longer. As a former trial lawyer, taking old evidence to a jury is difficult. So what's the idea to speed things up?
It is, and I recall the advice I got from a judge when I first started trying cases that delay always inures to the benefit of the defense, right? Just accept that and understand it. So we'd like to move our cases as quickly as possible. The downside of the international approach to these investigations and resolutions is that they do tend to take a lot longer. It's never, well, in my experience, it's not because our team is dragging their feet. I certainly put a lot of pressure on my teams to move as quickly as possible, not just because that's what's best for the investing public and the ultimate owners of these companies, but it's best for us because we can move on to other things. So we do try to expedite. I would say that in terms of an internal investigation, if that's what's going to be done ahead of presentation to DOJ, the more thorough, the better. It just helps us. If you bring us something that has a lot of loose ends, then we will, tie up those loose ends. It will take time to do it. But if you bring us something that is much more complete, then we're in a better position to move forward with our international partners. But we're certainly not seeking delay for the sake of delay because it does us no good.
I agree 100%. It's never in our interest. And I think some of what we're facing in this country, we've got to pursue what's called reasonable lines of inquiry. So we have some obligation to look at certain aspects of crime. Then there's a judgment call as to what is reasonable and how much looking you got to do. Because at the end of the day, we all know we're not going to get every single defendant in the dock. We're going to have to be a little bit practical. It can take time for us to get our cases into the courtrooms. We just have to be sensible about how we focus. So I've had a couple of ideas that we've put into place over the past year. One is a little more intelligence-led, where we are determining where we should be focusing our efforts, where the big bad crimes are happening, because that's what we're supposed to be managing and getting at, and also trying to make sure that we don't feel duty-bound to investigate absolutely every tentacle of absolutely every crime, that we look at the most culpable. If we get the top ring there and it looks like we've got 3-4 people that basically were running the operation, that we at least think about it, taking those people on. We can always do a second prosecution. And I'm trying to get all of my colleagues thinking a little bit like that, because it doesn't help us. Witnesses, memories fade, elderly victims don't necessarily make it to trial, defendants get sick and die. I mean, it really is not in the best interests of the taxpaying public to have these things go on forever.
And at least between the U.S. and the U.K., I suppose the Cloud Act and the COPO bill and the new data sharing arrangements between the U.S. and U.K. will help to expedite some of that investigation phase. Unfortunately, we don't have time to talk about that, and I'm getting the old heave-ho from the back of the room. So I'm going to bring this to an end, but I wanted to thank Rich and Lisa for a really informative and interesting discussion this morning and ask people to show their appreciation.